May it please the court, my name Ngo, NGO initial JN, and I appear on behalf of the accused Jane Beatson, an Indigenous 14-year-old from Townsville. Jane is charged with 5 counts of breaking and entering and committing an indictable offence, and 32 counts of burglary. He pleads not guilty to these charges. The defendant submit by way of Section 519 AA subsection 2E of the Queensland Criminal Code that the court exercises discretion excluding the Crown's evidence of admission made by my client during his interview at the police station and in the police vehicle at the time of his arrest. It is submitted that the evidence be excluded on the basis of 2 grounds. Firstly, it is on the basis of public policy. The evidence from my client's submission obtained by the police officers was in violation of several statutory requirements of public policy. Secondly, my client admitted to the offence through gratuitous concurrence. Therefore, it is highly unfair and the court should exercise discretion excluding such evidence. Your Honour, I will now move on to my first submission. It is submitted that the evidence tendered by the court be excluded from trial due to the police officers' failure to comply with several legal obligations pursuant to the Police Powers and Responsibilities Act, the PPRA. Firstly, Section 418, subsection 1 and 2 states that before a police officer starts to question for an indictable offence, the police officer must inform the person they have the right to communicate with a friend, relative, or lawyer. In addition, they must delay the questioning for a reasonable time to allow the person to speak to the person in the aforesaid. It is clear that the officer violated this legal obligation because my client James was not informed of these rights before questioning. Furthermore, my client is of Aboriginal descent. Therefore, subsequent to Section 420 relating to questioning of Aboriginal people and Torres Strait Islanders, the officer has failed to inform my client his rights to a legal aid representative. In addition, Section 421 is relevant to the contravention. It relates to the questioning of a child. A child is defined in the Youth Justice Act in Schedule 4 as a person who has not turned 17 years. Section 421 states that if a police officer wants to question the relevant person and they reasonably suspect that the person is a child, then it is clearly evidence that the officer here suspected my client was a child by referring to him as young fella. A further requirement of Section 421 is that the officer must not question the child unless the child was allowed to speak to a support person by choice. Here, my client was not afforded the opportunity to choose a support person prior to questioning. The defence counsel does acknowledge that the support person was provided, Mr. Roger Smith. However, the support person was a complete stranger to my client and was not the chosen person. I would like to direct your honour to the decision in Crown v. L, where it was deemed that a field officer was inadmissible as a legal aid representative and a support person for an Indigenous person. Thus, it is a transparent contravention of legal obligations pursuant to Section 421 and subsection 2A. In addition, Section 431, subsection 1 of the PPRA and Section 26, subsection 1 of the Police Powers Responsibility Regulation, the officer failed to caution my client his right to speak freely and remain silent. My client was advised by the officer to answer all questions, and this is a clear breach of statute. My last submission is pursuant to the PPRA section 436 relating to recording of question. The defense submit that the recording of the interview between my client should be excluded as evidence because it contained inaudible content, therefore breached statutory requirement. Your Honour, on the grounds of several breaches by the officer ascertaining evidence from my client, it is a clear breach of statute. In the case of Eleanor, it is important to protect the public and individual from unfair treatment from those who are in charge of upholding the law. To do otherwise would encourage the misappropriation of the law. In addition, the defense acknowledged the high cogency of the prosecution's evidence. However, it is greatly diminished by the statutory breaches by the officers. I would also like to direct the court to the case of Bunning v. Cross, where it considered the 5 factors relevant to determine the evidence if it should be excluded accordingly to public policy. Your Honour, on the second ground of fairness, the court to exercise discretion under Section 130 of the Evidence Act to rule the Crown's evidence inadmissible. The admission by my client occurred through gratuitous concurrence, thus it is more prejudicial rather than probative. Gratuitous concurrence is common amongst Indigenous people, where some tend to agree to the proposition put in front of them, although they do not agree or understand what they're agreeing to. This is a sign of respect in Indigenous culture. It is clear evident in the fact that my client, an Indigenous child, was intimidated by the questioning of the officer. In the case of Purcell v. Van der Noe, it has been highlighted that Indigenous people often face difficulty when facing authority. The evidence obtained by the Crown was done so through the means of gratuitous concurrence. Thus, my client's submission, is not a true confession of guilt to the charges. In conclusion, the defense submit the Crown evidence to be excluded on the basis of public policy and fairness discretion. Evidence were obtained through several breaches of statute and by means of gratuitous concurrence. Your Honour, on the basis of fairness, the court should deem the Crown evidence inadmissible. Thank you.